Edwards was a member of the National Union of Vehicle Builders, a trade union. The rules of the trade union established the contribution amounts which were demanded from members and said that those amounts could not be increased without a ballot of members and 2/3 approval. The union delegates increased the contributions anyway. Edwards refused to pay, and in the time-honoured fashion of union bullying, he was threatened and had certain union privileges revoked. Charming. He sought a ruling that the contribution increase was invalid. The union, in response, relied on the rule in Foss and Harbottle that an irregular decision by a corporation was not a matter for the court if it could be ratified by a meeting of the corporation. If that were so, then the contribution increase would be valid until a general meeting of all union members overturned it. Lord Justice Jenkins in the lead judgment used this as an opportunity to reduce injustices arising from the rule in Foss and Harbottle by setting out 4 circumstances in which that rule should not apply. He said it should not apply in cases where the act complained of is wholly ultra vires or beyond the power of the company or association. He went on to say, where what has been done amounts to what is generally called in these cases a fraud on the minority, and the wrongdoers are themselves in control of the company, the rule is relaxed in favour of the aggrieved minority, who are allowed to bring what is known as a minority shareholders' action on behalf of themselves and all others. The third exception occurred if the matter in respect of which the plaintiff was suing was one which could be validly done or sanctioned not by a simple majority of the members of the company or association, but only by some special majority. And the fourth was if the individual members who are suing sued not in the right of the union, but in their own right to protect from invasion their own individual rights as members. In this case, the decision in dispute required a special majority of 2/3, and the union members were suing in relation to their individual rights, not suing on behalf of the union itself. Consequently, the rule in Foss and Harbottle did not apply. The union's actions were invalid and the increases set aside.